Big news coming in from the Supreme Court of India. The Apex Court has said that no further suits or cases can be registered relating to the Religious Places Worship Act until the next hearing. The CJI has clarified that while suits can still be filed, they will not be registered until the matter is heard and disposed of. The Chief Justice of India cited the Ram Janmabhoomi case and reiterated that the matter is sub judice and therefore no new cases can proceed during the time of this hearing. In the hearing, senior counsel argued that surveys related to already filed suits should be stopped. The ruling came on petitions challenging the constitutional validity of the Places of Worship Special Provisions Act of the year 1991. This law prohibits filing lawsuits to reclaim or alter the character of places of worship as they stood on the 15th of August 1947. During the hearing today, Justice Viswanathan added that civil courts should not bypass the Supreme Court's authority, calling for a stay on further proceedings. Now we have Dr. Rajiv Nanda, Senior Advocate, Supreme Court, joining us on the broadcast for that big story that we're tracking over here. Dr. Rajiv Nanda, thank you so much for taking time out to be with us. Talk to us about the significance of this particular ruling by the Supreme Court of India on the Places of Worship Act.
Today, Supreme Court has said that no further cases can be registered during the pendency of this batch of writ petitions which are there. It only means that the cases will not be assigned any numbers. The Supreme Court has not stopped the filing of any petitions. They can still be filed, but they won't proceed. That means they won't be registered and there won't be any hearing of any such new filing. Today, let us not forget that Supreme Court is not only hearing the constitutional validity of 1991 Places of Worship Act, but also in the batch of petitions, there are petitions which are seeking the enforcement of such act. And mind it, the central government has not yet filed the response, whether in support of the 1991 Act, which was brought in by the previous government. Today, the BJP government, which is having its majority, can either support the 1991 Act or can also support the petition saying that it is unconstitutional, or they may say that we don't support this act anymore and we are going to bring in new legislation.
Right. Now, one of the key issues in this matter is that sections 2, 3 and 4 of the Act, which those who are against this particular Places of Worship Act, they claim that these provisions deny individuals and religious groups the right to judicial remedies to reclaim places of worship. And talk to us in that sense. Questioning the validity of this act in itself is something that the top court of the country is yet to deliver a verdict on.
See, it's all right to claim that my right to the religion under Article 25 and 26, etc., are being violated. But let us not forget that this act was brought in keeping in view the secular character granted to the country through the Constitution itself. The preamble says the sovereign democratic Republic of India having the secular character. So this is not violating as of now. This is not violating any of the articles of the Constitution. Supreme Court is to decide whether this 1991 Act is ultra virus to the articles of Constitution of India. As of now, nothing has been brought except some individual saying that individual or maybe some groups saying that their right to their invaded or destroyed temples are violated. But on the other hand, 1991 Act has been brought in keeping in view the secular character. And there is nothing ultra virus which has been brought on record as of now.
Right. It was a 3-judge bench, Mr. Nanda, Dr. Nanda, that heard that case. It included the Chief Justice of India, Sanjeev Khanna, Justices Sanjay Kumar and K.V. Viswanathan. And Justice Viswanathan had a specific message to the civil courts and the lower courts in the country. He specifically told them not to bypass the Supreme Court's authority. Where is that coming from?
Well, Supreme Court, with utmost respect to what has fallen from the bench, they don't need to expect these things. They have the authority and they should pass orders specifically saying or barring the civil courts not to proceed or not to take up any further matters. Just by expressing this, I mean, it is in good spirit that Justice Vishwanathan has said this, but then it will be better in case it is reflected in the order also.
Okay, and in terms of the progress of the case, where do things stand at this stage? A lot more progress needs to be made before a final verdict is delivered.
Hearing of such kind of matters cannot be done at 3:30. These kind of matters require days of hearing. It will have to be heard on a normal day when regular matters are being heard at 10:30 for maybe a couple of days, wherein the petitioners will argue that how they feel that it is violating their individual rights to the religion of declaring, getting it declared as their mandirs or their temples or whatever. And they will have to really bring in a case that this act actually violates their rights. Otherwise, just because they feel that this kind of declaration should be given, the 1991 Act is very specific. It is not going to change or alter or grant any right to any court to give such kind of declaration that there was some other kind of religious structure prior to the present one.
Right, stay with us. We also have my colleague Brijesh Pandey joining us from the newsroom. Brijesh, the Chief Justice of India specifically cited the Ram Janmabhoomi case, and in which he reiterated that the matter is sub judice, and that's why no new cases can proceed during this time of hearing.
Well, that was very clear, but I think it was only after the oral observation of the former Chief Justice of India, Justice D.Y. Chandrachud, that nobody is altering the structure, but everybody has a right to know as to what has happened. That has led to a plethora of such suits being filed, across the Uttar Pradesh and other places as well. And that is the reason why the suits or the courts are also admitting such suits, and they are ordering surveys to be carried out. And this is the reason why people have approached the apex court saying that these kind of surveys are to be announced till a final decision can be taken on whether the Places of Right to Worship Act 1991 can be amended or not, or the Parliament is going to bring in new rule, bring a new amendment to alter the structure of the Right to Worship Act 1991. But till then, I think most of the lower courts have gone by what the oral observations of Justice Chandrachud, and that is the reason why these orders are being given. I think with today's order, why it is effectively staying the entire matter till the next date of hearing and asking courts not to register, though it's not stopping people from filing such cases, but it's asked the lower courts to not entertain, to not admit any such plea, and there should be a stay till the next date of hearing must have come as a breather for the Muslim party for sure. And the court has also appointed 3 nodal officers, one from the side of Hindu community, one from the center, and also one from the Muslim side, who will be overseeing the entire gig. They have given 4 weeks to the center to reply on this matter. I think this is one of the important issues which was before the apex court, because there was a lot of confusion about the exact structure or the order of 1991, which I completely agree with Mr. Nanda, explicitly forbade from any kind of conversion. So this order must have come as a relief, but it will be very interesting to see what is going to be the stand of the central government.
Back in 2022, the Supreme Court of India, did ask the centre's response to the plea filed by Ashwini Upadhyay, challenging the validity of the provisions of the law of 1991. So it was the matter was supposed to be looked into by the centre a couple of years ago. So in that sense, with these cases being taken up by the Supreme Court, the suits challenging the validity of the law, it is time that the centre steps in.
Well, absolutely. Without centre informing the court as to how exactly it wants to proceed with this, without centre telling the court about what it thinks of the particular matter, I think it is going to be the validity of a 1991 judgment, and there's no, there's no change to that. So all of these orders, all of these surveys which have been issued by various local courts will stand infructuous. So the centre has to tell what exactly it has in mind, whether it is thinking of passing a law in the parliament to amend the Places of Worship Act 1991, or whether it concurs that there is no change which they are planning. So all of this, what exactly in the centre's mind, centre has to tell the apex court as far as this particular case is concerned. Otherwise, if you go by Places of Worship Act 1991, then apart from Babri Masjid Ram Janmabhoomi dispute, there was no other cases which have been mentioned before that. So all of this, there is like a likelihood of all of these surveys which have been granted and all being stayed put, and that is the reason why the court has asked the centre to to provide an answer in 4 weeks.
Right, stay with us. We also have Dr. Nanda with us on the broadcast. Dr. Nanda, it has happened in the Gyan Vapi case as well. April 2022, a Varanasi civil judge appointed an advocate commission to conduct a videographic survey. The High Court and later the Supreme Court refused to stop the survey with Gyan Vapi as well. Talk to us, the hearings that are taking place today, how significant will it be in terms of the way this law progresses from here on, whether it continues to stay or go, and more importantly, how soon do you think the Supreme Court will be able to take a call on it, and more importantly, will it be able to take a call on it without the centre's intervention?
The 1991 Act is very clear, section 2, 3 and 4 and 5, that there was only one exception carved out so far as declaration of the status was, and that was Ram Janmabhoomi. There is no other exception carved out in the Act. Now, all these suits which are being filed left, right and center, Gyan Vapi, Mathura, and now the mushroomed suits which are, I heard about Ajmer and all these, there will be no end to it. It is not that the center can't do it. Now, answering your second question, how the Supreme Court is going to tackle it, Supreme Court has to see, because what is before Supreme Court is the challenge to the constitutional validity of this Act. This Act, so far as it stands now, does not violate, in my view, any of the articles of the Constitution of India. To get it declared ultra-virus, it has to be violating any of the articles of the Constitution, and which I repeat, as of now, it does not. Now comes the role of the central government, which is very important. Now, in a way, the central government today will be in a catch-22 position, because the Act, no matter which government brought in, is an Act, is a statute. Now, either the central government can say that we do not agree with this 1991 Act, but their role will not end here. They cannot escape their liability or role by simply saying that they do not agree with the philosophy of this Act. Now, they have to take another act or bring in another legislation to repeal this 1991 Act. Otherwise, if it stands as of now, no matter the previous government with whom the present day government may not agree principally, has brought it, and Supreme Court is going to look at it the way it is standing as of now. So either the central government brings in the new legislation, or it just agrees to it. There is no third way that central government can do it. But their affidavit is going to be of very great importance.
All right. Dr. Rajiv Nanda, Senior Advocate, Supreme Court, they're joining us with that perspective. Thank you, Dr. Nanda, for joining us. Let's now listen into some of the reactions coming in from the lawyers arguing the case in the court.
माननीय सुप्रीम कोर्ट ने दोनों पक्षों को सुन लिया है। सुनने के बाद उन्होंने ओपन कोर्ट में कोई ऑर्डर नहीं पास किया है। अब वो ऑर्डर मुझे लगता है रात को लिखा जाएगा तो कल आएगा। ऑर्डर आज तक अभी कोई आया नहीं है। हमारा पहले से यही कहना था। दूसरी पक्ष का ये कहना था कि जो भारत में इस समय 18 मंदिरों का सर्वे चल रहा है उसको रोक दिया जाए। हमारा ये कहना है कि जहां जहां सर्वे का ऑर्डर हुआ है उसके पक्ष यहां आए ही नहीं है, और वैसे भी सीपीसी के अंतर्गत अगर कोई ऑर्डर होता है डिस्ट्रिक्ट कोर्ट का तो उसको हाई कोर्ट में चैलेंज किया जा सकता है। आप कानून को बाईपास नहीं कर सकते कि ऑर्डर हो रखा है डिस्ट्रिक्ट कोर्ट ने और सीधे उसको सुप्रीम कोर्ट स्टे कर दे।
माननीय सर्वोच्च न्यायालय ने आज के अपने आदेश में कहा है कि इस सारे मामले की सुनवाई अगली तारीख पर होगी, लेकिन उन्होंने एक आज आदेश पारित किया कि नए सूट रजिस्टर नहीं किए जाएंगे जहां प्लेसेज ऑफ वर्शिप एक्ट का मामला इन्वॉल्व होता हो। दूसरा, उन्होंने यह भी कहा कि जो सूट रजिस्टर हो गया है वो सूट तो चलेगी, लेकिन जब तक ये मामला सुप्रीम कोर्ट में पेंडिंग है, कोई इंटरिम ऑर्डर, कोई अदालत जहां ये सूट पेंडिंग है, जो मुस्लिम पक्ष ने कहा 18 सूट टोटल पेंडिंग है, उसमें कोई इंटरिम ऑर्डर पास नहीं किया जाएगा जब तक सेक्शन प्लेसेस ऑफ वर्शिप एक्ट का मामला इस कोर्ट में विचाराधीन है।
4 हफ्ते का सुप्रीम कोर्ट ने मतलब टाइम दे दिया है और 4 हफ्ते सेंटर को मतलब के तरफ डाल दिया है कि सेंटर मतलब जो है ना, जो 1991 एक्ट है उसके बारे में मतलब उसका क्या नज़रिया है वो बताए, और उसके बाद जो है बाकी अब आगे कोई मतलब जो है पिटीशन नहीं दायर होगा मतलब जो है सर्वे के लिए, ये सेंटर ने जो कहा है हम उसका हम स्वागत करते हैं।
In a major development, sources suggest that the Union Cabinet of India has approved a bill aimed at implementing the ambitious one country, one election proposal. The government is likely to introduce this bill in the current session of the parliament. Reports indicate that the legislation could be sent to a joint parliamentary committee or JPC for comprehensive discussions. This move follows the Cabinet's acceptance of the Ramnath Kovind Committee's recommendations on the subject. The government aims to build a consensus on the bill, promising detailed consultations with all stakeholders, including representatives from political parties, state assembly speakers, and intellectuals across the country. Opinions from the general public will also be sought. The Joint Parliamentary Committee will focus on the benefits and feasibility of the initiative during its deliberations. The government is optimistic that through dialogue and deliberation, a consensus can be reached to make one country, one election a reality.
उड़ीसा में देखिए एक साथ चुनाव हुए और आपको बार बार चुनाव में जाना नहीं है, लेकिन हमारा प्रदेश में वन नेशन वन इलेक्शन नहीं है। अभी हमने लोकसभा चुनाव किए, दोबारा अभी विधानसभा चुनाव करना पड़ता है, और जो साल भी आप लोकसभा या विधानसभा चुनाव करते हैं, लगभग पूरा साल में कुछ डेवलपमेंट का काम नहीं होते हैं। तो इसीलिए प्रधानमंत्री जी चाहते हैं वन नेशन वन इलेक्शन हो। हम लोग इसको पूरा समर्थन करता हूं, और मेरा मानना है कि ये भी जो अमेंडमेंट है, कॉन्स्टिट्यूशनल अमेंडमेंट है, प्रधानमंत्री जी इसको भी स्वीकृत करवा ही ले।
Former Delhi Chief Minister and Aam Aadmi Party Chief Arvind Kejriwal made a big announcement today for women in Delhi. Kejriwal promised to deposit 2,100 rupees into the bank accounts of all women above 18 years of age in Delhi every month. This comes as the Aam Aadmi Party gears up for the 2025 assembly elections. The move is seen as an attempt to woo women voters and secure a third term in power.
लेकिन इन लोगों ने दुर्भाग्यवश फर्जी केस करके मुझे जेल भेज दिया। जेल में मैं 6-7 महीने रहा, और जब लौट के आया तो लौट के आने के बाद से मैं इस स्कीम को, योजना को लागू करने में आतिशी जी के साथ लगा हुआ था। और मुझे बेहद खुशी है कि हम लोगों के मेहनत से, प्रयासों से आज ये योजना दिल्ली के अंदर लागू हो गई है। ये हम कोई एहसान नहीं कर रहे अपनी मां बहनों के ऊपर। महिलाएं अपना परिवार चलाती हैं, बच्चों को अच्छे संस्कार देती हैं, बच्चों को बड़ा बनाती हैं, बड़ा करती हैं पाल पोस के, और बच्चे ही देश का भविष्य हैं। महिलाओं के इस काम में अगर हम थोड़ी बहुत अपनी मदद कर सकें, उनका साथ दे सकें, तो हम अपने आप को सौभाग्यशाली समझते हैं। और अपने हिंदू धर्म में तो कहते हैं ना, यत्र नार्यस्तु पूज्यन्ते तत्र रमन्ते देवता। जहां नारी की पूजा की जाती है वहीं देवता बसते हैं। इस योजना के साथ मैं समझता हूं दिल्ली सरकार का खर्चा नहीं होगा, बल्कि दिल्ली सरकार की खूब बरकत होगी। मां बहनों के आशीर्वाद से दिल्ली सरकार की बरकत होगी। कुछ लोग कह रहे थे केजरीवाल कह रहा है हो नहीं सकता, ये तो हो नहीं सकता, ये नहीं करने देगा, वो नहीं करने देगा। हो गया है ना। केजरीवाल जो ठान लेता है वो करके रहता है, फिर कोई दुनिया की कोई ताकत नहीं रोक सकती। दिल्ली के मेरे 2 करोड़ लोगों के साथ मिलके हम बड़ी से बड़ी अड़चनों को पार करके हम अपने सारे काम करवा लेते हैं। कोई अड़चन हमारे सामने किसी काम में नहीं आती। बीजेपी वाले गालियां दे रहे हैं कि केजरीवाल तो पैसे लुटा रहा है, केजरीवाल फ्री की रेवड़ियां बांट रहा है। बीजेपी वाले कहते हैं फ्री बिजली देने की क्या जरूरत है, बीजेपी वाले कहते हैं फ्री बसों में यात्रा देने की क्या जरूरत है। अभी मैं किसी महिला को सुन रहा था कि फ्री की रेवड़ी खाएंगे मोटे होते जाएंगे। तो अभी बीजेपी वाले ये भी कह रहे हैं पैसे कहां से आएंगे, इतने पैसे सरकार के पास पैसे नहीं है। यही बात वो तब भी कहते थे जब मैंने पिछले 2013 के चुनाव में जब मैं लड़ा था 2014 में, तब मैं कहता था बिजली फ्री कर देंगे, और बीजेपी वाले कहते थे केजरीवाल झूठ बोल रहा है, पैसे कहां से आएंगे। मैं बीजेपी वालों को कहना चाहता हूं मैं जादूगर हूं।
गोपाल राय जी हमारे साथ है। गोपाल जी, महिला यहाँ 1000 की उम्मीद लेके आई थी, 2100 रुपए बोल दिया आप लोगों ने।
देखिए 1000 रुपए के इस साल के लिए बजट में हमने पास किया था। आज अरविंद जी केजरीवाल जी को जेल में डालने से उनको रोकने की कोशिश की, आज कैबिनेट ने उसे पास कर दिया है। अरविंद जी ने आज एक बड़ा ऐलान किया है कि चुनाव के बाद अगले साल से 1000 से बढ़ा करके 2100 रुपए महिलाओं के अकाउंट में डाल जाएंगे।
वो तो चुनाव जीतने के बाद होगा, अगर होगा तो। दूसरा 1000 के लिए आपको इतना मशक्कत करनी पड़ी, 2100 के लिए आपको लगता है ज्यादा टफ होगा?
कैबिनेट में पॉलिसी पास हो गई
उसे लेकिन प्रक्रिया क्या होगी, 2100 करने की प्रक्रिया क्या होगी?
नहीं, कैबिनेट में पॉलिसी पास हो गई है। वो तो कैबिनेट उसको जितना अमाउंट, जैसे वृद्धा पेंशन है हमने 1000 था बढ़ा दिया, वैसे महिलाओं के जो सम्मान राशि थी उसे बढ़ा करके 2100 कर देंगे।
ये गेम चेंजर होगा सर?
देखिए महिलाओं के लिए, उनके परिवार के लिए गेम चेंजर होगा।
ठीक है। तो गोपाल राय जो कि दिल्ली सरकार में मंत्री हैं, साफ तौर पर कह रहे हैं कि 1000 किया है तो 2100 भी कर देंगे, और इसको लेकर के चुनाव में लोगों के बीच में अरविंद केजरीवाल जाएंगे, इस योजना के बारे में बताएंगे किस तरीके से महिलाओं के लिए अलग योजना चलाई जा रही है, और हो सकता है इसका फायदा चुनाव देखने को मिले।
Reacting to the scheme, BJP's Amit Malviya hit out, saying that Aam Aadmi Party failed to deliver a similar scheme in Punjab, and now Delhi is next in line. He said till date not a single sister in Punjab has received a single rupee, and the excuse given is the empty state of the government treasury. It was said in Delhi that the money would be transferred to the sisters' accounts by October, but that too turned out to be a blatant lie.